Good morning, ladies and gentlemen. My name is Christoph Spennemann. I'm in charge of the Intellectual Property Unit at UNCTAD, the United Nations Conference on Trade and Development. Thank you very much, first of all, to Third World Network and to the Asia-Pacific Network of people living with HIV for having me at your important conference. I'm very sorry not to be there in person, but I think we have found a good way of making this presentation online, and I'm very happy to have the opportunity to talk to you today. I will talk about policy coherence and technology transfer for local pharmaceutical production. First of all, of course, what is UNCTAD, the United Nations Conference on Trade and Development? We are the focal point within the United Nations system for the integrated treatment of trade, development, and interrelated areas of finance, technology, and investment. So, in other words, what we seek to do is we seek to promote the integration of developing countries into the world economy. At UNCTAD, we have a program on intellectual property rights and their implications for development. Specifically, what we have been working on is intellectual property in the context of local pharmaceutical production and intellectual property in the context of transfer of technology. In my presentation now, I would like to dwell a little bit on the lessons that we can draw from this work. So we can actually draw three main lessons from our work on intellectual property. First of all, TRIPS flexibilities play a very important role in promoting technology transfer in the specific case of least developed countries, or LDCs. Second, for local production, however, many other elements are needed, so it is not sufficient to only look at the flexibilities of the TRIPS agreement, but we need to consider many other factors that I will elaborate on in a minute. Thirdly, as far as technology transfer and local pharmaceutical production is concerned, it is very important to look at potential cooperation with foreign holders of technology. This is essential for LDCs if they want to promote local production and technology transfer. Those foreign technology holders could be both originator companies or generic companies. Well, let's have a look at some economic evidence on the relationship between intellectual property and technology transfer. Here I'm referring to a paper that was written by Professors Keith Maskus and Kamil Sagi in 2014 for the WIPO Committee on Development and Intellectual Property. According to Maskus and Sagi, in the specific case of LDCs, exclusive rights like intellectual property rights can be important obstacles to technology transfer. In the case of large and advanced developing countries, they reach the opposite conclusion. But in the case of LDCs, the problem is that much of technological learning happens through informal means, like, for example, reverse engineering. Now, you can imagine that through exclusive rights, like a patent, for example, reverse engineering is made impossible and illegal. So for that reason, in LDCs, these professors come to the conclusion that exclusive rights could prevent important obstacles to tech transfer. So the recommendation here, of course, is that LDCs, rather than promoting exclusive rights, should more look into limitations and exceptions to intellectual property rights. LDCs should also focus their policies on the promotion of education, providing links between firms and universities, and of course attract investors by non-intellectual property factors such as the promotion of human capital, trade and economies of scale, and political stability, much rather than exclusive intellectual property rights. So, in accordance with these findings, UNCTAD has advised many least developed countries on how to design intellectual property rights in their domestic context. For example, UNCTAD in 2016 issued a report for Nepal on the development dimensions of intellectual property in Nepal, transfer of technology, access to medicines, genetic resources, and traditional knowledge. In this report, we recommended that Nepal exclude pharmaceutical patents from patentability in line with the WTO transition period until the year 2033. Second, we recommend that Nepal introduce narrow patentability criteria and wide patent exceptions, for instance, in the areas of generic approval and R&D. Thirdly, we recommend that Nepal avoid exclusivity in pharmaceutical test data protection. Now, this being said, however, it's important to stress that local production, in order to be successful, needs much more than intellectual property flexibilities. Intellectual property alone will not do the trick because, of course, generic formulations in many cases could be off patent. So, for example, in our recommendations to the Nepalese government, we also stressed other factors that the government should implement going much beyond intellectual property. For instance, we recommend that imported raw materials that generic producers need for their production should be exempted from VAT and from certain tariffs. We also recommend that there should be a preference for local producers in government procurement policies. Thirdly, we recommend that there should be concessionary loans for investment in local production, so that, for example, that you can apply, for example, favorable interest rates for local producers. Finally, what we also recommended beyond intellectual property for Nepal was certain income tax exemptions that could be linked to milestone achievements. For example, if a local producer achieves the production of an essential medicine. So this importance, the importance of a coherent set of policies beyond intellectual property, has been emphasized in an UNCTAD publication that we came up with in 2018. It is called the Toolbox for Policy Coherence in Access to Medicines and Local Pharmaceutical Production. In this toolbox, we stress the need for a comprehensive policy mix that local production needs in order to be successful. First of all, what really matters is to provide support to local producers in investing in quality production. As you know, meeting quality production requirements is very difficult, so local producers need to invest in upgrading of their quality. So this is something that we stress very much along the lines of our recommendations of the report that we did for Nepal. Another important issue that we find in that toolbox that makes local production successful is to harmonize drug regulation. And there, for example, we can see that in the East African community, there is a medicines registration harmonization program that seeks to promote such harmonization of drug regulation, which in our view is very important. Something also that we stress in the toolbox is the support of local innovation. So rather than just looking at intellectual property or patent protection, we stress the importance of providing linkages between local universities and the local industry. We also stress the importance of disclosing the best mode in patent applications that are filed with the patent office, so that competitors can better understand how a certain patent works. Finally, we stress the importance of appropriate intellectual property incentives that are appropriate in an LDC context or in a developing country context. So this is not necessarily related to patents. These could be utility models or compensatory liability regimes. Let me dwell a little bit for a few minutes on what are these compensatory liability regimes. These regimes could also be referred to as use and pay regimes. This means you don't have an exclusive right, like a patent, under which you could exclude your competitors from using your invention, but you have the right to fair and equitable compensation if others decide to use your invention. This could be an interesting policy option for economies that rely on follow-on, small-scale innovation and improvements. You can imagine that these small-scale improvements are not necessarily eligible for patent protection. So you need to come up with an alternative way of protecting them. In addition, if you protected them through patents, this would require the negotiations of multiple licenses with all these follow-on inventors that are keen on using an existing invention for small follow-on improvements. So for that reason, a use and pay model may be more appropriate in those circumstances. It is interesting to see that these kind of use and pay models have already been used or have been suggested in different contexts. For example, in Swiss patent law, a use and pay model has been suggested on patented research tools. I will explain this in a few minutes. It's also interesting to note that EFTA, the European Free Trade Association, has suggested the option of use and pay in its free trade agreements on the protection of pharmaceutical test data. You're probably aware of the fact that under free trade agreements by the EU and the United States, pharmaceutical test data are usually protected under exclusive rights. That means that the generic company may not rely on originator test data in the context of approval of generic drugs. However, under EFTA free trade agreements, there is an option not to go through the exclusive rights, but rather to apply the compensatory liability regime, basically to allow generic companies to rely on originator's test data, but then of course to compensate the originator for the use of such test data. Now, I mentioned before the example of Switzerland and their use and pay regime. It is interesting when you look at the Swiss law on patents that Article 40b of the Swiss Patent Act actually talks about patented research tools. And I can read the provision to you. It says that any person who intends to use a patented biotechnological invention as an instrument or means for research is entitled to a non-exclusive license. Now, why is this provision interesting? Because it is about a patented research tool, but it actually follows a different approach from the traditional patent. Under a patent, you can normally exclude your competitors from using your invention. Under this specific Swiss provision on biotechnological research tools, the patent holder does not have the right to exclude its competitors, but it must grant the research tool, the use of the research tool to its competitors, but has a right to receive equitable remuneration for the use of its research tool. The tricky question, of course, is what happens if the patent holder and the users of the invention do not agree on the amount of the royalty that the patent holder should receive. In that case, according to Swiss law, they have to go to the court to let the court decide on what is a fair compensation for the use of such a research tool. Well, going beyond intellectual property now a little bit, what are other tools that local producers can be supported by? A very important tool is public procurement of medicines to support local producers. Pooled procurement is a very interesting topic, is a very interesting tool. Pooling procurement by different national governments, of course, may increase their purchasing power. An example of a very efficient regional procurement is actually the West African Health Organization, which has a regional entity to procure from producers that are based in the Economic Community of the West African States, ECOWAS. That's a regional procurement entity. In the East African Community, as another example, they do not have a regional procurement entity, but they have national procurement entities that try to harmonize their national procurement laws to enable regional procurement. Again, to increase their purchasing power and to make the market more interesting for pharmaceutical producers. Something else related to procurement, of course, is to apply price preferences for local producers in public procurement. Ethiopia, for example, provides a 25% price preference to local producers over foreign suppliers in its domestic law. This is something that other LDCs could also engage in. It is probably important to mention that a number of free trade agreements may limit this flexibility of using price preferences in public procurement. For instance, there is the free trade agreement between Vietnam and the European Union that limits the flexibility of Vietnam to apply this kind of price preference because it obliges the Vietnamese government to introduce the criteria of the World Trade Organization's government procurement agreement, which basically makes these kind of price preferences impossible. So when countries want to apply price preferences in procurement, it is very important to have a look whether certain free trade agreements prevent this kind of flexibility. Beyond procurement, another important tool to promote local production is, of course, to apply export subsidies for local producers. You may know that export subsidies are normally prohibited under the World Trade Organization's Agreement on Subsidies and Countervailing Measures. But the good news here is that this agreement does not apply to least developed countries. So we have an example, for example, from Bangladesh that has very wisely used this flexibility under WTO law. Bangladesh has been promoting export subsidies to its local pharmaceutical producers, for example, up to 50% income tax exemption for export earnings. For example, a duty-free import of machinery for export-oriented facilities, and finally, certain tax holidays that also apply to its domestic industry when they are engaged in the exportation of pharmaceutical products. So again, it's important to note that export subsidies are something that could be very interesting to LDCs. Another important tool to make local producers more successful and more sustainable is, of course, strategic drug selection. I think we agree that local production should contribute to national public health systems and national public health concerns. So it is, of course, good if a company can engage successfully in the production of certain lifestyle drugs, medicines, but that, of course, is not very important for the country's public health system. So my point here is that it would be important, from my view, from a governmental perspective, to tie certain public policy measures or to tie the industrial policy measures that I've been describing to the production of medicines from the country's essential medicines list, so that producers are supported through public policy measures only if they agree to produce medicines that are on the country's essential medicines list. That seems quite important. Also, to ensure quality of the drugs, in my view, reimbursement schemes, for example, under health insurances, should only cover those drugs that obviously meet certain quality standards, and not drugs that are under those quality standards. I would now, at the end of my presentation, come to one topic that is very important to highlight. That basically means that for local production, it is not only important to look into TRIPS flexibilities and into coherence of policies, but it's also very important for successful local production to look at cooperation with foreign holders of technology. This is because these foreign holders of technology can bring in very important know-how that LDCs lack, or that industry in LDCs may lack. UNCTAD engaged in a series of case studies a few years ago that is called Local Production of Pharmaceuticals and Related Technology Transfer in Developing Countries. You can find a link to this series of case studies in my presentation, in the slides that I make available along with this presentation. What we did is we looked at a number of pharmaceutical companies in countries that are at very different level of development. The countries were Argentina, Bangladesh, Colombia, Ethiopia, Indonesia, Jordan, Thailand, and Uganda. So you can see these countries were at very different levels of development. We specifically looked at companies and how they engaged with foreign investors and foreign producers in the production of pharmaceuticals locally. Beyond that, we also looked at the policy level. We looked at the legislation and the policies that prevailed in those countries during the time of the investment. So what are the main lessons that we can draw from these case studies? There are basically lessons at two levels, at the policy level and at the company level. The lesson that we can draw at the policy level was that we need a conducive policy environment to enable local pharmaceutical production and technology transfer. First of all, we need a predictable and stable political conditions and investment protection in order to attract foreign investors. The second thing that is really important is a stable and reliable research and development community in the country, which is promoted through strong linkages between the domestic university, between the domestic industry and domestic universities. So these linkages are often missing in many developing countries, but they are very important to build domestic capacity. And that domestic capacity in turn will attract the foreign investor. Thirdly, what we can see is that at the policy level, it is extremely important to have an active patent office, a patent office that will help its domestic industry identify what are the patents and what are the inventions that are available in the public domain, and how to better understand existing patent applications and what is the technology behind them. So an active patent office is also something that is very important in this conducive policy environment. Now, the second lesson that we can draw from our case studies is that beyond a conducive policy environment, we need at the firm and the university level, we need firms and universities in the beneficiary countries that have the capacity to understand intellectual property, that have the capacity to deal with contracts, with licensing contracts regarding intellectual property, and that know something about intellectual property management. For example, universities, they should have an idea about intellectual property and patents. Do they have a patent policy? Are they aware of what should happen with publicly funded research and development? Should they seek patents on those on this research, and how should they deal with these patents? Should they license these patents out to the industry? Should they be more exclusive, or should they be more public domain oriented about these patents? These are things that universities have to be aware about. Then second, of course, it is very important for universities and also for domestic companies to be aware of intellectual property contracts, like licensing agreements. For example, what are the scope of the rights in a licensing contract? Is this an exclusive license, or is it a non-exclusive license? Do they have the right to license their invention to other people? What is the amount of the royalties that they have to give, or what is the amount of the royalties that they are entitled to receive? Then certain competition issues, of course, that are related to a licensing contract. For example, is there an obligation of exclusive grant backs? An exclusive grant back is a clause that obliges a licensee to grant back any improvements that it has made to a patented invention, to grant this back to the patent holder. That may not be in the interest of the licensee, but it may be included in a licensing contract. So basically, patent holders and licensees have to be aware of the implications of these kind of clauses in a licensing agreement. In my presentation, I also mentioned a number of other clauses that patent holders and licensees have to be aware of. So, coming to the conclusions in my presentation, the first conclusion, of course, is that local production is a very complex objective to realize that requires coherence among various sets of policies, not only on intellectual property, but also in relation to health, drug registration, drug procurement, trade, investment, and other issues, such as, for example, subsidies that I mentioned. Second, TRIPS flexibilities play a very important role in local production and technology transfer, but they alone are not sufficient to promote this objective. TRIPS flexibilities are very important to enable domestic learning through reverse engineering, but on the other hand, what we need in addition to this is cooperation with foreign investors, because they hold the decisive technology, they hold the decisive know-how, and this kind of know-how can be made available through partnerships, through licensing contracts that domestic producers can agree with foreign producers. So, my point is that TRIPS flexibilities are extremely important. countries need to have them on the books, they need to know how to use them, but on top of that, they need to enable partnerships between local companies, local universities, and foreign investors. I will be very happy to respond to any queries, any questions you may have about my presentation. You can find my contact details here in this presentation in my slides that I'm making available. I would also be very happy to engage with you in follow-up discussions on potential technical cooperation that we as UNCTAD could engage in with your countries, potentially in cooperation with Third World Network and other partners. And I thank you very much for your attention. Thank you very much.